to be our adjunct professor. And we would like to streamline and enhance the position of adjunct professor, so that it would really benefit the kuliah and the faculty. And that's why in the list of tasks is quite a number of tasks. And we are thankful for Prof. Bakar Munir for agreeing to rise up to the challenge, I suppose. For him, not much of a challenge, but for us, yes. For us to achieve whatever we set out to do in terms of the curriculum, in terms of research, and also in terms of our networks with relevant parties, with professional bodies, with other institutions, because Prof. Bakar Munir certainly have his network, so we like to engage with his network in order to enhance our programs and enhance our research. For our adjunct professors, both of our adjunct professors, we tie the adjunct professor together with our research group, relevant research group. For instance, for Tansi Rastam, we have the Southeast Asia Plus that looks at the regional affairs in particular, and on the setting up on the ASEAN, for instance. For Prof. Bakar Munir, we pair together with the Media and Communication Research Group. That's, I suppose, the forte of Prof. Bakar Munir. And of course, looking at the title for our adjunct professor lecture series today, certainly that's tell us the expertise and the experience that Prof. Bakar have in the area of information technology and also including renewable energy. So we look forward to the lecture that Prof. Bakar will deliver, and we look forward also for the activities and the cooperation that will nurture in this couple of months to enhance our curriculum and our research. And of course, with that, I would like again to thank Prof. Munir to agree to take up the challenge with us as our adjunct professor. Thank you. Assalamualaikum.
Thank you, Prof. Farid, for the kind welcoming remark. And before we continue with the lecture, I have a pleasure to share with everyone a brief profile of Professor Bakar. I have to mention brief because otherwise it will be very long. Yes, Prof. Bakar has been well-known academic, especially he has spent most of the time with University of Malaya. He got his Masters of Law from University of Warwick in UK in 1989, and before that he graduated with his LLB in University of Malaya in 1984. And since then, I think he joined University of Malaya, and yes, has been known as the professor in University of Malaya. And at one time also he held the position of the Dean of the faculty in the Faculty of Law of the University of Malaya. His areas of specialization, of course I didn't mention that he recently retired from the University of Malaya, so therefore we are here grabbing him out of his retirement. The professor's areas of specialization has been cyber law and cyber law policy, data protection law, nanotechnology law and policy, air and space law, as well as renewable energy law and policy. So everything about technology. So it really reflects what he has outlined as his lecture today. It's about law and technology, looking into the future. So Professor Bakar has also held some positions as adjunct professors in some renowned institutions in the country as well as outside Malaysia. I think that is all what I can share. I mean, in order to limit myself and in the interest of time. And again, thank you, Professor Bakar, for your time, for being with us here. Now, I'd like to welcome you to deliver your lecture.
Thank you very much, Dr. Tony. Bismillahirrahmanirrahim. Assalamualaikum. Thank you so much, Professor Farid, the Dean. And first and foremost, I would like to thank Ahmad Ibrahim Kuliah Law for giving me the opportunity to perhaps contribute, to the Kuliah and community of the IIUM and perhaps the students. Yeah. So for today's discussion or presentation, rather, don't be disappointed if you expect me to talk about the interactions between law and technology, because we can read for ourselves, the interactions between the two, law and technology. And don't be disappointed if I'm not going to talk about what would be the future in terms of law and technology. What I'm going to do here, in line with the team, or in line with the theme of the occasions, which is Adjunct Professor Lecture Series. So perhaps what I'm going to do is that to talk about what I've done in the past in terms of research, and looking into the future, meaning that what we can do together and what other academic or academicians outside IIUM can do in terms of research, specifically looking at internet technology or information communication technology. So with that in mind, let's get started. All right. So law and technology, as I said, I'm not going to talk about the interaction. And looking to the future, basically looking into what we can do together between myself and IIUM or AIKOL and academicians. The first slide, Sonny, please. Okay, a little bit more about myself. Of course, Dr. Sony has mentioned briefly some of my activities and my affiliations, and this is little bit more. I'm an adjunct professor at the Faculty of Law in the State of Indonesia, international visiting professor of cyber law and arbitration law at the Faculty of Law in the State of Pajajaran. And a couple of months ago, I founded Asosiasi Professional Privacy Data Indonesia, APPBI, and we have been very active in organizing programs, specific programs for privacy professional, and alhamdulillah, we have received overwhelming response from the Indonesian society. I mean, especially the professionals. Yeah. And I'm also the co-founder and director of Bali International Arbitration and Mediation Center, or BIMNC. We have two offices. One is in Bali, the other is in Jakarta. And we have been doing programs successfully, and we have collaborators all over the world, including Singapore, even New York, and Hong Kong. And recently, Kuala Lumpur International Chamber of Commerce, without application from my side, KLICC, since they are doing a big project in Bakar. So they were looking for experts in the area of cybersecurity and privacy, and they said, "Are you willing to contribute?" I said, "Yeah, why not?" And they just, appointed me to be their consultant for that project in Bakar. And then in Tokyo, there is an institute called Asia Pacific Institute for the Digital Economy. So we run programs as well, seminars and conferences that we call experts from all over the world. It's headed by former director of Microsoft, yeah, James whatever, I can't remember his name now. Yeah. Then I'm also a research consultant at Harry Elias Partnership Singapore. He used to be Eversheds. Harry Elias. Evershed is one of the biggest law firm based in London. They have got an office in Singapore. And apart from that, I'm acting as a senior advisor to a couple of legal firms in Jakarta as well as Bangkok. So it's quite busy actually. But I'm still willing to contribute to IIKOL, inshallah. Yeah? And in fact, through this networking, perhaps we can work together, especially the IMC. I have informed them that I'll be joining as an adjunct professor at IIKOL. They said, yes, let's collaborate. In the past, these are some of my publications. As early as 1999, I published a book on cyber law, policies and challenges, in 2002 on privacy, 2004 on internet banking, 2010 on general IT law. Yeah. Next, again, data protection law in 2010, then data protection law in Singapore. I contributed a chapter in that. Then data protection law in Asia in 2014. Then in 2018, data protection law in Asia, again, second edition. Data protection law in Singapore, again, second edition. I contributed a chapter. Then there was basically IIUM report on Malaysian blockchain regulatory report. And then a chapter in that book, Regulation of Cross-Border Data Transfer, published by Asia Business Institute in Singapore. Yeah. Next one, sorry, please. These are get closer. Yeah. Okay, these are quite recent articles. I'm not going to discuss that, but some of my papers on this, on data protection and what happened in the UK about the law that has been shot down by the European Court of Justice. I remember I was I was in Glasgow, and the decision was made by the European Court of Justice, and I said, let's quickly write something about this decision, and we came up with that article, Data Retention Rules, and published in the European Data Protection Law Journal. It is a dream of academicians, especially in science and engineering fields, to get their works published in Nature. So it's a bit strange, isn't it? A law professor can penetrate Nature. So if you know Nature is actually it's a very reputable journal, the impact factor is 47, 48. And of course, my paper is a very short one, but I'm still very grateful that it has been accepted by Nature. In 2016, it was published in 2016. Yeah. And then, as you may know, I was instrumental in helping the government of Malaysia in coming up with the Personal Data Protection Act 2010. I would say, single-handedly, basically. And then I just completed my assignment with the Republic of Indonesia. We have come up with a draft on PDP, or personal data protection. And the news I received yesterday evening is that it is going to be finalized in June, latest by June this year. Okay. Pelan Tindakan Hak Asasi Manusia Kebangsaan. I was the chief or the leader for this project, and alhamdulillah, we managed to secure 3.2 million for this project by the government, and we came up with a report. Then, at the early stage of the development of the Singapore Personal Data Protection Act, I contributed by sending out some of my comments and analysis of the draft bill at 10. Yeah. Next one, Government of Dubai. When I was at the University of Malaya, I was seconded to the Government of Dubai as a legal advisor to the Government of Dubai and principal consultant. Then with a team of legal experts, we developed some legislation for the project, something like our Cyberjaya project, okay, or MSC Malaysia. I was fortunate in my career as an academician to be appointed as the head of delegations to Malaysian head of delegations to the meeting in Vienna in the office of United Nations for Space Affairs. I spent 2 weeks there talking about legislation, how to legislate outer space. Basically, at that time the issue was cyber debris, space debris. LM is a company based in Riyadh. I was fortunate, was given the opportunity to help them in terms of compliance with the international best practices in terms of privacy and data protection. And that's it. Work in progress. Yeah. These are some of the things. A book chapter is going to be published soon. Economic sanctions and cyber warfare is going to be published by Hart Publishing. Then an article, Revisiting Right to Privacy in the Digital Age, is going to be published by the MCL. This is IIUM Law School journal. Contact Tracing in Singapore, article in draft. I hope I can finish it by end of the week. If you remember, contact tracing is a very common because I will call it 19. And what triggers me to write this paper is that data that has been collected by Trace Together Singapore, just like our MySejahtera, is going to be used or will be shared with the police for the purpose of crime investigation. And I thought this is a very serious matter. So what I did was I contacted my daughter, and we are writing a paper or an article on this. And then I'm working on data law in India with a collaborator, a lawyer in India, in New Delhi. We have completed 6 chapters so far. And then with a collaborator in Colombo, we are writing a book on data law in Sri Lanka based on the draft law. Okay, and research on fake news. Enough of myself. Let's look at what we can do together in terms of research, publication, and consultancy, perhaps. Yeah. And I think the future is now. Let's have a look at some of the recent developments. Yeah. Let's have a look at some recent development and opportunities to do research together and to publish papers or to come up with publications. I think everybody in this room and even outside is aware of the fact that the government of Malaysia recently came out with this and launched this Malaysia Digital Economic Blueprint. If you look at Trust 3, it says review laws and regulations to improve provision for digital infrastructure. Who are going to do this? Perhaps we could take the challenge. Yeah, we academicians or academics should take the challenge to do the research and perhaps submit the recommendations to the government. Yeah, and Trust 6, strengthen data protection and related regulatory framework to ensure holistic personal data protection. Again, this is another opportunity to do research, yeah, and perhaps come up with publication. Yeah, this is one. Let's look at the other one. So again, this is Malaysian Digital Economic Framework. Specifically mentioned there, completions of enhancement to PDPA. Our PDPA is going to be enhanced. Who is going to do the research for the purpose of, mentioned there, for the purpose of cross-border data transfer. Yeah. And then specifically mentioned PDPA to be reviewed by 2025, right? And 70% of companies to adopt cyber security measures by 2025. Yeah, perhaps this is technical. Then the other things, the other development happened during this COVID is the launch of cybersecurity strategy by the government again. So mentioned there in Pillar 2, strengthening legislative framework and enforcement. It specifically mentioned the first order of this pillar is to study and review all the following legislation. You look at the list of the legislation. There are so many. So who is going to do this? We should take up the challenge to do the research, yeah, and come up with the publications and recommendations to assist the government of the day, right? Let's move on. Then again, during this COVID-19, ASEAN launched ASEAN Economic Community Blueprint 2025, yeah, and under B7, title B7, effective, efficient, coherent, and responsive regulation and good regulatory practice. It mentioned there, undertake regular concerted regional programs of review of existing regulatory implementation process and procedures. To me, this is another opportunity that we should conduct research on this. And specifically, e-commerce C353. Yeah, it says this include, but not limited to, strategic measures such as putting in place the following: harmonized consumer rights and protection laws. Very broad. Yeah. So consumer protections who are involved in consumer protections, then consumer rights should take up this challenge. Yeah. Harmonized legal framework for online dispute resolution. So ASEAN is planning to do this, taking into account available international standards, interoperable, mutually recognized, secure, reliable, and user-friendly e-identification and authorization in terms of electronic signature and perhaps digital identity, because digital identity is one of the things now being encouraged even by institutions like World Bank, IMF, and United Nations. And as you may know, Malaysia plans to do this as well. A paper has been published, I think, a couple of months ago about digital identity. Yeah. The last one is coherent and comprehensive framework for personal data protection. Again, yeah. So a lot of opportunities for us to collaborate and come up with research and publication and perhaps consultancy. Let's move on. Another perhaps initiative, the ASEAN Framework on Digital Governance. Of course, it's mentioned there, well, there are a few pieces of legislations that form the foundation of digital economies. A particular area of focus is on the development and harmonizations of personal data protection regulations. Yeah? ASEAN member states should endeavor to work towards establishing personal data protection regulations in their respective countries. Perhaps we can do some kind of mapping, in ASEAN, try to assess which countries, countries that have not come up with the personal data protection law, like Brunei, Vietnam, Myanmar, we can assist them. Yeah? Using the framework that has been established by ASEAN in this area. Okay, next one. This is another development. During COVID, ASEAN and other RCEP members or countries or member countries have signed this. And recently, as we know, China has agreed to move forward. Yeah, they have signed it. And as we know, there are 20 chapters in there. And of course, I think we need to do research on the impact of these RCEP. Each chapter deserves perhaps research and publication. And if we look at chapter 12 on e-commerce, yeah, and I reproduce here one specific article, Article 12.8, on online personal information protection. Each party shall adopt or maintain legal framework which ensures the protection of personal information of the users of electronic commerce. In the development of legal framework for the protection of personal information, each party shall take into account international standard, principle, guidelines, and criteria of relevant international organizations or bodies. So we can make an assessment whether or not data protection law of a particular country, for example, is in line with the international standard. Even we can do that in Malaysia to make an evaluation or assessment of the PDPA or PDPA in Singapore or even in other countries. Yeah. This is interesting. I think it happened in this month, no, last month on 25th March, there is a committee in the US. Zuckerberg was asked to give evidence, and then Google was asked, then Twitter was asked to give evidence on, how and what they have done to address the issue of fake news. Yeah. So based on what I have read, the report that have come up from this hearing, US is moving towards legislation, towards having a legislation. Specifically, what we are trying to do is that to amend Section 230 of the Communications Decency Act. Yeah, and you can see the response or the evidence given by Zuckerberg, Twitter, and Google. Yeah. So, of course, this is US. Perhaps we can do research on fake news here in Malaysia and ASEAN, because ASEAN has issued a kind of a document saying that ASEAN is very concerned about fake news and we have to address fake news. The question is that how to tackle fake news. Yeah. In fact, we can do a comparative study. In Europe, in the EU, the approach is code of practice. Yeah, code of practice. Basically, EU has come up with code of practice on misinformation. So companies like Facebook, Google, Twitter will have to subscribe to that. But again, I think based on what I've read, my research shows that sooner or later, they are going to legislate. As we know, Malaysia has taken a legislative approach to address fake news. Then we may ask whether or not it is effective. Yeah, or should we have other measures to tackle or to address fake news? Again, based on my research, I think Finland is one of the most successful countries in the world that has managed to address fake news. We need to study Finland. Yeah, I think one of the initiatives adopted by Finland is what they call as digital literacy. Apart from self-regulatory plus digital literacy plus fact-checking. So what I'm trying to say here is that there is room for research here for us to do some research on this global issue of fake news. Yeah, it is a global issue. Okay. In terms of what we can do together, or even what academics outside, meaning myself and AIKOL, can do is that we need to have new programs. I think we can organize new programs in line with the developments of the world today. LLM in cyber law, for example, LLM in technology and law. Yeah, we can have we specialize in emerging technology or disruptive technology or emerging technology to be more focused. Yeah, because there are so many technologies available now: artificial intelligence, gene editing, and then renewable technology, and then coding, and so many technologies. We can choose certain technologies and have a program on that technology and law. Yeah, LLM in privacy and application law. Not many universities around the world doing this. One of them is Maastricht University. Then, of course, international body like IAPP, International Association of Privacy Professionals. Yeah, but they run short courses. Sorry. Yeah. There are a few new programs.
Oh, sorry, still here?
No, it's not there.
Sorry.
So otherwise, we can just go there.
Let me just check. Sorry. Yeah, it's still there. It's still presenting.
Otherwise, I can just use the left.
That is in. Sorry. Or you just
I can
let's see it
there.
from here. I'll just show it to you while I'm.
Okay. So, I mean, we can basically, we should think of new programs, yeah? As I mentioned, we can explore having LLM in cyber law, LLM in law and technology, LLM in privacy and data protection.
Sorry. Looks like it freezes here. Mine. Look like it freezes here, so I'm putting that. It's coming back very soon now. Okay. Sorry, it's been frozen now. Okay, it's coming back. The pin. Pin.
Okay. Thank you, sir. Thank you, Galen. Okay, these are some of the new programs that we can explore to have, LLM in law and technology. As I said, we can specialize in certain areas like interactive technology or certain technologies, emerging technologies. We focus on emerging technologies like digital technology and then perhaps artificial intelligence and so on. Yeah. LLM in privacy and data law, not many countries, not many universities around the world doing this. Yeah, I know Maastricht is doing this. LLM in renewable energy law and policy. Yeah, again, not many universities doing this. Not many higher institutions having this program. MSc in renewable energy or solar energy with collaborators in the UK. You may ask why MSc? Because when I was appointed, even before I received the appointment letter, I contacted my collaborators in the UK. Are you willing to collaborate with us if we want to have this program? I said, yes, anytime. But we have to discuss the detail. And why MSc? MSc is a very common program there in terms of renewable energy. But of course, with the elements of law and policy and finance. So, it's a comprehensive program on renewable energy or solar energy specifically. Yeah? So, we can look up the detail. DPO or Data Protection Officer training course. I would like to focus on this, because the potential is huge. Okay, why DPO? Why DPO? Sorry, next slide, please. Mandatory appointment of DPO. As of now, there are 128 countries that have enacted legislation on data protection. So in their legislation, DPO is mandatory. All the 27 EU countries, 27, it used to be 28, now because of Brexit.
Minus Britain.
Yeah, all the 27 countries in EU require DPO to be appointed, meaning that certain companies and organizations need to appoint DPO, Data Protection Officer. Yeah, Singapore is mandatory. And the Philippines, yes, mandatory under the Philippines Act. It is mandatory to have DPO. Korea, Thailand, and India. India in the draft bill of the Indian law, data protection law. New Zealand, New Zealand, of course, the UK, mandatory. And in the Middle East, Egypt is the most recent country came up with the comprehensive law on data protection. And when I checked the legislation, the act, there is a requirement for certain companies and organizations to have DPO. In the Sri Lankan draft law, yes, there is a requirement for that. Nigeria, I've seen the draft of the Nigerian law. There is a requirement to have DPO. Canada, the draft law of Indonesia, as I said just now, yeah, Indonesia is finalizing the bill, and I was informed by June, it should be enacted, and South Africa. So you see the potentials if we have this program. Yeah. Next slide, please. DPO as best practice. Japan, yeah, it's not mandated by the law. It's not mandatory for organizations to appoint DPO, but they have issued guidelines and encourage companies and organizations to appoint DPO. It may be called Chief Privacy Officer or other designations, but people responsible in managing the compliance with the law. Yeah, Hong Kong, same thing, but the regulator in Hong Kong encourages people or companies and organizations to appoint DPO. Malaysia is a best practice yet, but let's move on to the next one. As we know, perhaps Dr. Soni knows this, recently the government of Malaysia has issued a consultation paper. In there is a proposal for DPO to be introduced in the legislation, PDPA. Yeah? So there is a possibility, even in Malaysia, it is mandatory for companies and organizations to appoint DPO. Okay, of course, we can work out the detail, what kind of programs, what kind of syllabus, or module that we can work out on this. Let's move on. This is interesting statement. Forget about data scientists. Data protection officer is the sexiest new job. While the recruitment sector has been focused on the hunt for data scientists, many of whom will enjoy the first, second, and fourth of those privileges, it is the data protection officer, DPO, which is set to become the most desirable and sexiest job of this decade. It's long statement. Let's move on. This is from IAPP, as I said, International Association of Privacy Professionals. The privacy profession has been growing steadily since its inception, but it exploded in the last 2 years with the coming into force of the EU General Data Protection Regulation in 2018. Yeah, because EU regulation started this DPO requirements. Yeah. So privacy and data protection professionals have never been busier or more in demand. You can see, you can have a look at some indications of their package or salary in the US. Next, DPOs are mini chief executive officers of their respective organizations, are in fact well positioned to become the next CEOs. This is from the reports in the Philippines, the regulator in the Philippines, basically. This is from Fortune. Data privacy workers have become hot commodities in the business world as legislators and consumers increasingly call for strong data protection. Companies are increasingly hiring people who are specialized in privacy one way or another. Yeah. Over the past 4 years, since 2019, the number of openings with the terms data privacy or data protection in their titles on the employment side indeed have increased 75%. Yeah, let's move on. This is again the statement, this is a statement by the regulator in Singapore, the importance of having DPO to ensure compliance. An organization with highly placed professional DPO may well avoid a finding that it has violated the PDPA even though there was a data breach. Next slide, please. Again, this is from Singapore. The role of the DPO is critical to the success of every enterprise. In Singapore alone, there are 30,000 DPOs registered with the regulator who provides the training. Okay, so data protection officers becoming more important. Again, from Singapore report in Singapore. Next slide, please. The world is evolving, so are the competencies of the DPO. The the DPO role is quickly advancing from data protection managers to regional and even global DPOs. I think we should start thinking of having a program covering not only Malaysia, not only individual countries, perhaps APAC or even world CPO. I mean, world DPO. Yeah. Next slide, sorry. Why should a data protection officer be global? Yeah. So this is my last slide. Sorry, today. To me, talking about our students, our graduates, yeah, we used to say law school basically, would like to see their students to think like a lawyer, but thinking like a lawyer is no longer enough. New realities require lawyers with new knowledge and skills. Yeah, and I think we can work together, or let's work together. And I would like this. I would like to quote this Henry Ford. I think we know Henry Ford. Yeah, coming together is a beginning. Keeping together is progress. Working together is a success. So thank you so much for listening. If there is any question.
Thank you. Thank you, Professor Bakar, for very enlightening and also provoking. Let me fix this first. Great, Prof. Having seen where you come from and the engagements that you have had in the past, it really gives us a clear idea of what is coming. And you have put it very, very clearly for us. And we really thank you. And for this, hopefully we can plan further for our research as well as our academic activities in the future. So in this precious occasion, as you said, you will be welcoming some questions, Prof.
Yeah,
we can welcome some questions. Is there any question from this room, by the way? You from ready? From you? Okay,
Yeah,
Dr. Nasser. We welcome Dr. Nasser first. Right.
I saw the area relating to protection, but I think there's one area that we can explore. Now it's a very hot issue. The interface between competition law and data protection.
Right.
Yeah, because I might area that now people start to use competition law to address the issue of data protection, especially in the case of Facebook, Google, and all that. So we have so many cases.
Yeah. And I agree. And when I was in Bali, there was a presentation by someone from Jakarta. I think it's a very excellent presentation to see the interaction between competition law and data protection law. If you're keen, I can link you to that individual. I mean, she's doing research on that. Yeah. Any other questions on it?
Yes. We can welcome questions. So far, we don't see a question in the chat room first, but if any participant in this Google Meet would like to ask question directly to Professor, please. We have Dr. Bama from Multimedia University.
Yeah.
Right. Good afternoon, Prof. Thank you very much for that very illuminating talk. I'm actually from Multimedia University, and I think two of my colleagues were your students, Dr. Sunny and of course Rasha. I myself am very interested in cyber law. I teach cyber law, and I've been teaching cyber law with Dr. Sunny when he was with MMU. The issue that I would like to ask, I know you can't stop somebody. There's noise interference from somebody. I know that you can't obviously answer everything within the short period you have, but I would like to know what is the impact of the GDPR on Malaysian companies, and how is that going to be the provisions of the GDPR, are they going to be incorporated into our, I heard that our PDPA is being revised. Are those provisions going to be incorporated or similar references in our own local act? Thank you.
Thank you so much for the question, Dr. Bama. I think you asked about the impact of EU GDPR on Malaysian companies, yeah? So if you look at Article 3.2 of the EU GDPR, yeah, it has extraterritorial application. You know, as long as, I mean, if I can remember correctly, Article 3.2 or 3 of the EU GDPR, in simple terms, it says if you are monitoring of European citizens, yeah, GDPR will apply to you. Or if you are doing some kind of activities involving EU citizens, regardless of your location, then EU GDPR is applicable to you. You may ask in terms of practical aspect, how is it going to be implemented? Yeah. So there was a case in Canada recently. You know, the regulator in EU or in Europe took actions against a Canadian company through the regulator in Canada. So what I'm trying to say is that it has happened. It is possible for this law, even though, you know, theoretically it's maybe difficult, but it has happened and action has been taken. And in terms of, I mean, looking at it from other aspect, because of EU GDPR, if you look at the Directive 1995, it doesn't cover data processors. But now EU GDPR says, you know, data processors are also covered. So because of that, many European companies now, before they engage data processors around the world, including companies in Malaysia to be their processors, they will do a kind of assessment whether or not you understand your obligation as data processors in the context of EU GDPR. I was informed based on research that I've read, the report, many companies in Malaysia, Singapore, Asia have been eliminated from being processors of European companies because they are not able even to answer some basic question about EU GDPR, which means, you know, they don't understand EU GDPR. So there are practical impacts actually of EU GDPR on Malaysian companies or companies around the world, as long as you are dealing with European companies and European citizens. Not European citizen, it says, you know, European, it can be European citizen, it can be someone residing in Europe, because this law, EU GDPR, applies to everybody, you know. I hope it answers your question, Mama.
Yes, Prof, it has answered my question and it has raised another question. So, the chances of the application of the Canadian situation to the Malaysian situation is highly likely. Is that right?
I can't hear this one. Can you get it?
The Canadian case that you were referring to?
I didn't get it, Mama.
Sorry. The Canadian case that you are referring to, chances are it could very well apply to the Malaysian context.
Would it apply to Malaysian context, this Canadian?
Okay, I will type.
Well, it is possible because if you look at the report, based on the Canadian case, as I said, they implemented the EU GDPR through the regulator in Canada. I think the same thing can happen here in Malaysia as well.
Thank you, Prof. Thank you.
Yeah.
Thank you, Dr. Bama. May I invite any other question, please? Perhaps I can raise one.
Sure.
You did mention one of the critical area is about the border data, cross-border data transfer.
Yeah.
And when it comes to Asia, Southeast Asia and ASEAN region, there has been some efforts to among Asian nations to have this digital framework. Do you foresee there is any escalation from that framework, whether it is possible for ASEAN countries to have more binding mechanism when it comes to trans-border data transfer, at least for the ASEAN region?
Very interesting question, Dr. Soni. Recently, I think last month, ASEAN came up with the model contract for the purpose of data transfer. I can share with you the contracts. Basically, I think they realized that ASEAN realized that different countries in ASEAN have some different rules in terms of data transfer. So to facilitate data transfer within ASEAN and beyond ASEAN, especially to Asia Pacific countries because of the APEC, we have come up with the ASEAN model contract clauses. Basically, what it means is this: if you are a Malaysian company, you want to transfer data to other country within ASEAN, you can adopt that model contract. So once you adopt that model contract, it is okay for you to transfer data to other country, even if that country doesn't have legislation yet on data protection, like Vietnam or Myanmar or even Brunei. I think Brunei needs help in terms of the okay. So yes, at least ASEAN has come up with the model clauses on contract for the purpose of cross-border data transfer. I think it's a good model. I've seen it, and I've used that for my DPO program as well. Okay, then.
Thank you, Prof. There's one question here from Professor Tahir, our associate professor in AIKOL. Assalamualaikum, Prof. My interest is in the application of technology to legal profession and judicial services.
All right.
What the Malaysian universities and law school can do, maybe can anticipate in terms of this development to be adopted in their teaching and training.
Thank you. A lot of research has been done on this. Some reports are saying that most of the job done by lawyers now can be done by machine. I'm not sure whether you have heard about robot lawyers. I'm not sure whether you have heard about marriage lawyers or whatever. And then a lot of apps basically have been developed, and some predictions say that certain activities of lawyers will be eliminated, after certain years because of machines are more effective to handle that. Okay, so even in judiciary, as you may know, you can use artificial intelligence basically to predict a decision. You can even know what would be the result of a trial, for example. So a lot of developments, and in fact, I've read a book by one very famous professor in the UK about this, and I think a lot of initiatives have been done by universities in the US, especially, to train their students in terms of technology. I mean, when they go out, they should be able to manage the technology, then solve some of and do some of the jobs being done by persons or people. So yes, it is interesting development, and we should look into that as well.
Great. So many things coming up, Prof. We can raise so far no more questions in this chat room, but we have from our colleague, Dr. Mahyudin. No.
Data protection is an emerging area. If you look at my slide, I mentioned ELM. Can you
ELM.
Okay. Just to motivate our students, perhaps, slide number 3, 4.
ELM is it? Sorry.
And then I can see that.
Pin dia buka dulu pin. Unpin. Tukar.
Okay, you see the logo at LM. LM is basically a company based in Riyadh. Basically, if you travel to Riyadh or any airport, if you land at Riyadh or Jeddah, you see people without uniform at the immigration counters. They are not immigration officers, They are basically employees of this company called LM, processing data on behalf of the King of Saudi. So I was asked by this company, I think a couple of years ago, to come over to Riyadh to help them in terms of, even though Riyadh or Saudi doesn't have law yet, but they are working on the bill. When I was there, I heard that bill has been developed, and I was given the opportunity to meet some of the government officers there. So LM is a company in Riyadh processing data on behalf of the Saudi government. I was asked to go there for a week, and most of the time I did the work through in my room in a hotel for a week, and it's quite attractive. Basically, I was paid 100,000 for that for a week
in US.
Malaysian after conversion, 35,000 USD. So what I'm trying to say is that it's an emerging area basically, and it's getting more and more important nowadays because of the data. Because data, according to World Economic Forum, is the new oil of this century.
We have one question coming in, Prof.
Yeah.
Talking about fake news,
Yeah.
Malaysian government currently mentioned about using the ordinance, the emergency ordinance to curb or to address fake news.
Yeah.
Your opinion about it?
I think we know that before the present government took over, PN government has introduced a law on this fake news, Anti-Fake News Act. It was abolished by the PH government. And during this emergency, PN government has introduced emergency ordinance, and fake news is one of the issues. Yeah, this is my opinion. It is a very serious issue. Fake news is a very, very serious global issue. Yeah, especially during the pandemic. Yeah, especially during the pandemic, a lot of reports have been produced, and public safety and public health are affected because of fake news. Yeah, and whether or not legislation is the solution, I think we need to study that. Okay. Apart from that, I think more needs to be done in terms of, as I said, Finland. The case of Finland. Finland managed to address this issue through digital literacy, and of course, fact checking. We have fact checking, yeah, sebenarnya.com, whatever, sebenarnya.my. Perhaps that is another area that we should study, whether or not sebenarnya or fact checking is efficient to address this. Because based on my reading again, sometimes it's a bit too late. The news is already out, and then people have read it, and it has been duplicated, million and million. Only then, sebenar.my came up with this statement, this is fake. So it's a bit too late, you know. So a study on fact-checking or fact-checkers are needed, and a study on legislations also required, whether it is effective. Yeah, it has to be multiple measures. Digital literacy, legislations, of course, we have to ask, we have to question what kind of legislation, you know, and then and other things, and fact checkers, and what kind of fact checkers as well.
Prof, perhaps one last question, Prof.
Yeah.
I mean, given the time, there's Dr. Suryanita from now she's attached with the University of Indonesia in Jakarta, asking about DPO. Is it a system or a regulation for organization, or is the system or DPO system is actually a regulation about organization? I don't really.
Okay.
Maybe you can get.
Yeah. DPO is actually a dedicated individual or even an entity in the organization in charge of compliance and other things related to compliance, like awareness, like auditing, data protection impact assessment, all those things. So you're talking about what are the duties and functions of DPO, basically to ensure compliance with the data protection law. Yeah.
Okay.
Thank you so much.
Well, it's been short but very yeah, short, but we feel we really need more time actually. But surely that this is meant to be like a kickoff meeting for us, Prof, and also to really share with the audience how much we can go in future and the areas of priorities that you have really highlighted so well. I hope this presentation really benefits everyone who has been here. Thank you. We have visitors from some countries, Bangladesh, I guess, Indonesia, of course. We have friends from there coming in. Thank you. And then someone from Nigeria, Mauritania. Well, thank you so much. And of course, from Malaysia. Thank you for your coming here. And if you wish to have more, okay, we are looking forward to provide with you the slides for you. So we'll be reaching you through email, inshallah. So thank you, and for all those who have posted questions, thank you very much. We shall call it and close it now. Thank you, and till see you again one day. Yeah, thank you everyone who has been involved.
Thank you.
Let us close with reciting Surah Al-Asr. Bismillahirrahmanirrahim. There's actually a request from my fellow organizer for a photo session. Of course, this is absolutely your yeah, upon your consent. If you wish to put your camera on, I'm going to take the picture of the audience here on the screen. So you can choose to switch it on, switch your camera on. Then we're going to take the pictures. Okay, we allow some time for everyone to switch on the camera. All right, few more people are coming in. Thank you. So one, two, three. Okay, a few more. One more. 1, 2. How you want to put your best smile of the day? 1, 2, 3. There you go. Thank you very much. Thank you again. Assalamualaikum warahmatullahi wabarakatuh.